My name is Jeff Morgan. I'm going to read a paper that was given to me by Shelby Sharpe, and it's called No Fault Divorce, Unconstitutional and a National Catastrophe. Number one, the unconstitutionality of no fault divorce. Justice Felix Frankfurter, in a concurring opinion in Williams versus North Carolina, writes that a divorce decree without due process of law is, quote, without legal sanction in every state. A right protected by due process, according to Ray versus Northworthy, is one that cannot be taken without the opportunity to make a defense or the privilege of showing that the pretext of doing it is unfounded. In light of these proclamations from the law of the Supreme Court of the United States, measured against the requirements of no-fault divorce laws in Texas, it demonstrates unequivocally that the no-fault divorce laws in Texas are unconstitutional. Number two, the state of affairs prior to no-fault divorce. Prior to 1970, when no-fault divorce began to be enacted in various states, the divorce rate in the United States was approximately 2.5%. The fault system that was in existence in all of the states at that time had worked well from its inception. There was no outcry that the fault system was not working, but no, we got to get rid of this fault system. There was no outcry like that. The number of families experiencing divorce in the United States was an extremely small percentage. During this period of time, our culture was not facing the issues of animosity of one group against another like they are today, including mass shootings, other than civil rights movement and some labor disputes. The importance of the family unit to society has been expressed frequently by the courts. For example, the Supreme Court of the United States, as early as 1888 in Maynard v. Hill, characterized marriage as the most important relation in life and the foundation of family and society, without which there would be neither civilization nor progress. The court reaffirmed this characterization and importance of marriage approximately 90 years later in Zablocki versus Redhale. In 1848, the first Supreme Court of Texas, in an opinion written by Chief Justice Hemphill, stated as follows: "This engagement, marriage, is the most solemn and important of human transactions. It is regarded by all Christian nations as the basis for civilized society, of sound morals, and of the domestic affections. And the relations, duties, obligations, and consequences flowing from the contract are so important to the peace and welfare of society as to have it placed under the control of special municipal regulations independent of the will of the parties." So even by the two people who wanted a divorce, that was not even permitted. There had to be special regulations that were governing marriage because of the importance of marriage to society. Hemphill went on to observe that the prospect of easy separation foments the most frivolous quarrels and disgusts into deadly animosities. He concluded that when husbands and wives know that they cannot end the relationship by mutual consent or for light or frivolous reasons, they become good husbands and good wives, for necessity is a powerful master in teaching the duties it imposes. 65 years after Sheffield, the Supreme Court again wrote in Grigsby v. Ribe, "The contract of marriage is the most important of all human transactions. It is the very basis of the whole fabric of civilized society." What changed in society that warranted a change from what was working so well? Point number three is this: what was the motivation for no-fault divorce? When a system of law works so well for over 100 years, logically something happened that caused it to be jettisoned. What was that? It certainly was not based on any studies of the effects of the fault system. Prior to 1970, when no-fault divorce began, there were no studies published indicating that the fault system was not permitting divorces that were truly needed. The basic argument for no-fault divorce was to take the animosity out of divorce proceedings. That seemed like a reasonable objective, but the objective failed to take into account what Chief Justice Hemphill warned would happen in Sheffield v. Sheffield, that marriage was too important for society to be dissolved by mutual consent or for any light or trivial cause. Yet the arguments for no-fault divorce were persuasive, and by 1980, almost every state in the United States had some form of no-fault divorce. Point four, the cataclysmic consequences of no-fault divorce. Since 1970, America has experienced the destruction of over 1 million families annually. The economic reduction of millions of women and children to the poverty level and below, and by the way, also men too, when they have to pay child support and they're forced to go and live with a friend or family, or maybe move to another state and do some stuff on the black market. Number 3, the need for government assistance of all kinds for these millions of people. Number 4, a substantial increase in remedial and other specialized education programs for school-aged children of these families. Number 5, an increase in the school dropout rate of children from single-parent families. Divorce creates high school dropouts. Number 6, a doubling of the trial court system and the necessary support personnel for it and related government bodies to deal with matters arising out of divorce litigation. I've heard one judge said that over 60% of all judicial matters in the state of Texas, at least in his courts where he's the judge, are related to family law. 67%. Family law is a made-up fiction, largely, governed by no-fault divorce, of course, and other things, but 67%. We could get rid of 2/3 of the judges. The attorneys would have to go find a new job. The child custody evaluators, the guardian ad litems, they would all have to be put into a different place if we got rid of no-fault divorce. Some of these big courthouses, the family courthouse in Fort Worth, we're going to have family court here. We could get rid of that edifice, that monstrosity. Number 7, a sizable expenditure of funds in connection with appearances before these courts and related bodies. Number 8, an increase in crime, including unprecedented mass shootings where shooters are from broken homes or never formed homes. Number 9, incalculable economic losses by our national economy because millions of people affected by divorce have lost time from their employment or places of business, and that's absolutely true. Anybody who goes through divorce knows that this is the case. It just takes your mind off of it. And even our servicemen, when they're overseas and they're in combat and they find out that their husband or their wife has filed for divorce, their mind can be so caught up in what's going back in the States that their service member who's beside them, that they're responsible for, could be killed by a bullet because their mind is disengaged. Number 10, a dramatic increase in medical professional costs to deal with emotional and health consequences caused by divorce. Divorce is not an easy thing to go through. Divorce, if you look at the adverse childhood experiences studies, is one of the biggest things, one of the biggest contributors to the ACE scores. People can be impacted by divorce 20, 30, 40 years later. Sometimes the impacts of divorce last a lifetime. Some people get over it quickly. Statistically speaking, most people do not. All of the wars in which Americans have fought, combined with all natural disasters and diseases affecting America, have not caused as much damage to the American people as no-fault divorce. By any definition, no-fault divorce must be considered a national catastrophe. Point number 5 is replace no-fault divorce with the fault system originally used. Every legislature in the United States should re-examine its no-fault divorce laws in light of the consequences that have come about since the passage of no-fault divorce. In Texas, we call it Texas Family Code Statute 6.001, insupportability. We don't even know what it is, but all a person has to do is allege insupportability and he or she gets a divorce. Automatically, there is no way to stop it. No due process, no equal protection. There's many ways that statute is unconstitutional. This has been even noted in Waite versus Waite by Justice Kem Thompson Frost back in 2001. The statute, there is no way to make that statute constitutional, to have it comport with the Constitution and with judicial case law. The people are entitled, you are entitled to be informed of these consequences. You should know this. The percentage of increase in the number of divorces. You should know the cost to taxpayers for increased government services to broken families, which include educational programs such as remedial education, increased number of courts and court-related personnel to handle the so-called legal proceedings, the fake legal proceedings. Number 3, the impact on our criminal courts caused by crimes committed by those that come from broken homes, as well as the victims of those crimes. People that come from broken homes are more likely to commit crimes. We should know what those numbers are. The relationship, number 4, the relationship of broken homes to mass shootings. And that has been documented. It may have been incorrectly documented in some ways, but the vast majority of shooters come from broken homes. Mass shooters come from broken homes. Number 5, the economic impact on women and children of divorce, and again, men as well. and even sometimes extended family, because extended family gets involved with this. Number 6, the health and emotional problems suffered by members of broken families with their attendant costs. Number 7, the cost to our economy as a result of members of broken families not being present on the job to provide services and to produce goods. When all of these facts are communicated to the people, the legislatures of the 50 states will have no difficulty being motivated to repeal no-fault divorce statutes and return to the fault system that served the states so well. And this is written by an attorney, Shelby Sharpe. He's out of Fort Worth, Texas. He has successfully handled many constitutional law cases in the courts. This is his observation as an attorney, as a Christian, as a person who knows that no-fault divorce is an actual national catastrophe and it's blatantly unconstitutional. Thank you.